Hello and welcome to yet another episode of the In News series. My name is Pooja Dwivedi. Today we are going to discuss what has the Supreme Court said about appointments in the Election Commission of India. This is a verdict that will lead the way forward for ECI to be unbiased, neutral and of course serve its purpose more properly as a constitutional body. Now from the perspective of GS Mains Paper 2nd as well as from the perspective of your preliminary examination, these are the myriad points that we are going to discuss step by step. First of all, let us look at the news. Now, a 5-judge bench of the Apex Court of India has unanimously ruled, that means they all were of single narrative, that a high power committee which should consist of the Prime Minister, leader of the opposition in the Lok Sabha and the Chief Justice of India should appoint the Chief Election Commissioner and the election commissioners. Now this comes because the Constitution has not provided any sort of process with respect to the appointments, and this creates a lot of ambiguity and a lot of scope for abuse of power that can be actually used to get biased decisions by the Election Commission of India. So it's important that the Apex Court has said that. Now, if we have to talk about the background, let's go back to 2015, when a public interest litigation was filed by Anup Baranwal, claiming that the constitutional validity of the practice of the centre appointing members of the Election Commission is biased in nature, because which centre would want to get someone on the post of as the Chief Election Commissioner if they do not want the powers to be biased towards them? So this was the challenge by the PIL. Then in 2018, a 2-judge bench of the Supreme Court referred the case to a larger bench because this was talking about an important article of the Constitution, that is Article 324. And Article 324 is very important for a democratic country like India. So this was one close examination of Article 324 of the Constitution. And what is the mandate that defines the mandate of the Chief Election Commissioner? Article 324. This was to be examined. Now comes 2022, September 2022, a 5-judge constitution bench which was headed by Justice K.M. Joseph. They began hearing the case and almost after a month, the verdict was reserved. Now, this bench also consisted of Justice Ajay Rastogi, Justice Aniruddha Bose, Justice Hrishikesh Roy and Justice C.T. Ravi Kumar. Now, Article 324 Clause 2, if we have to talk about the challenge, there are certain ambiguities. Let's look at it. The Election Commission shall consist of the Chief Election Commissioner. One member is already mentioned. And such number of election commissioners, if any, as the President may from time to time fix. So, how many election commissioners should be there along with the Chief Election Commissioner is not given in the Constitution of India. It has been left on the discretion, as in it looks like it's the discretion of the President, while it's not, because the President actually depends upon the aid and advice of the Council of Ministers, largely the Parliament we can say. And the appointment of the Chief Election Commissioner and other election commissioners shall subject to the provisions of any law which is made in that behalf of the Parliament be made by the President. That means Parliament has been empowered under this article to define any number of election commissioners along with the CEC, and then the President will appoint them. Moving on. Now the challenge is that since there is not any sort of law that has been enacted by the Parliament on this issue, the court must step in to fill in the constitutional vacuum. The Constitution has mandated, but if the Parliament is not doing its work, then the Apex Court, the upholder of the Constitution of India, will come to work. Now, the larger question will also be there on the separation of powers. Where do we draw a line between where the Supreme Court has a say and where the Parliament has a say? And if the judiciary is overstepping its role in filling the gap, because the law has to be made by the Parliament. The Constitution is very clear on this. Who is the Supreme Court to say that Parliament should do it, or the Supreme Court brings out any sort of procedure for appointment of the election commissioner? So, is there any sort of judicial overreach that has to be also examined? Okay. Now, there are two main questions that were asked: whether the process of removal of the two election commissioners must be the same as the CEC, or also regarding the funding of the EC, how the election commission is getting funded. The more any party is giving as funds to the EC, the more the biasness will be there towards that party. So, in what manner should the funding be there? Moving on. Now, there are just 5 articles. Article 324 to 329 in part 15 of the 15 of the Constitution of India. Article 324 of the Constitution vests the as in puts the power of superintendence, direction and control of the election in an election commission, which consists of the chief election commissioner and such number that was in Article 324 clause 2 that I told you. Okay. The Constitution doesn't lay down a specific legislative process. That means a law is not there for the appointment of the CECs and the ECs. So, it becomes open to abuse and interpretation. The current procedure is like that the law minister suggests a pool of suitable candidates to the Prime Minister for consideration. And when that is shortlisted, refined, then the President makes the appointment on the advice of the Prime Minister. So, it looks very biased. Moving on. Now, what are the powers of the election commissioner if we have to say? See, June 15th, during the debates of the Constitutional Assembly, Baba Saheb Ambedkar said that the whole election machinery should be in the hands of the Central Election Commission, that means the Election Commission, which alone would be entitled to issue directives to returning officers, polling officers and others. And that is why 2 important acts were enacted, the Representation of the People Act of 1950 and the 1951 Act. Now, the apex court in the Mohinder Singh and another versus the Chief Election Commissioner, New Delhi and others said, Article 3, this is what the Supreme Court stated, Article 324 operates in areas left unoccupied by legislation. That means where there is no law enacted that specifically mandates anything, there Article 324 operates in those areas. And the words superintendence, direction and control as well as the conduct of all elections are the broadest terms. That means how do we see what is superintendence, how much control the CEC must have, and what these are the broader terms. So there is no proper definition. And also 324 is a plenary provision vesting the whole responsibility for national and state election in the Election Commission of India and therefore the necessary powers to discharge that function. So this was said by the apex court. Now the Election Commission, Condition of Service of Election Commissioners and Transaction of Business Act of 1991, it requires that the EC Election Commission and the Chief Election Commissioner must hold the post election commissioners as well as CEC. This was given in an act. So, must hold a post for a period of 6 years, and this law essentially governs the condition of service of both CEC and EC. So, this is a preliminary fact. Now, the current issue in which the verdict came, Justice Joseph authored, although the verdict was unanimous in nature, but Justice Joseph authored the majority opinion, while Justice Rastogi, he authored a separate opinion which agreed with the majority view. See, that the verdict, if we have to quote, the appointment of the CEC and the EC shall be made by the President. Okay, this is very clear, like the Constitution say. But a committee should be formed. The committee should consist of the PM, leader of the opposition of the Lok Sabha, and in case there is no leader of the opposition who is available, then the leader of the largest opposition party in the Lok Sabha, in terms of what? Numerical strength, the numbers, and the Chief Justice of India will also be a part of it. So you see, the executive, legislative and the judiciary all are in this committee. We make it clear that this will be subject to any law to be made by the Parliament. That means the Supreme Court made it very clear that we are not going against the Constitution. If the Parliament says that no, we are not going to have any sort of committee, or this verdict is not, it's a judicial overreach, then the Parliament can undo the effect of the SC verdict by bringing in a new law on the issue. That means there has to be a law, so that these kind of petitions don't come. Now, how did the Supreme Court reach on this verdict? See, all the members were very, very clear that the election must be conducted by an independent commission, the forefathers. And it was a radical departure from the regime which was prevailing under the Government of India Act 1935. Of course, it had to be. We were moving towards a democratic country. Now, there were also certain terms which were explicitly said that be subject to the provision of any law made in that behalf by the Parliament. See, Parliament was supreme in the matters of ECI that was said by the Constitution Fathers, of course, the Founding Fathers. Parliament would step in and provide norms. This is very clear, which the verdict also reinstates, and which would govern the appointment to such a uniquely important post as the post of Chief Election Commissioner and the Election Commission. Now, the government argued that in the absence of such a law, the President has the constitutional powers, because it is already written also, although Parliament is also written, but President, according to the government, had constitutional powers. The government has essentially asked the court to exhibit judicial restraint. Do not come into this matter. Do not say anything into this matter. This is what the government was saying. The court in its ruling discusses at length its intention to maintain a delicate balance on separation of powers. Executive should be the best in their own field, judiciary should do good in their own field, and legislature should do good in their own field. Now, was the Election Commission always a three-member body? No. See, until 1989, the Election Commission was a single-member body. It had only the Chief Election Commissioner. Now, Rajiv Gandhi's government was not doing great with the Chief Election Commissioner back then. So, ahead of the election to the 9th Lok Sabha, there was an atmosphere of friction between the Rajiv Gandhi government and the CEC Shastri. So, what happens that they say that, of course, because of the lowering of age, now new age was there, that voting can be done by those who are 18 years and above. So, there is too much work. CEC, you wouldn't be able to handle the responsibility. Let us get you more election commissioners. So, Rajiv's government was apprehensive what Shastri might do, the CEC might do during the Lok Sabha election of 1989, as it was a single-member body. So, on October 7, 1989, President R. Venkataraman issued a notification creating two positions of the Election Commission, and Article 324 Clause 2, under that only this power was used. So, on October 16, 1989, the government appointed S.S. Dhanwa and V.S. Sehgal to these posts. Now, Prime Minister V.P. Singh, Congress lost after that, by the way, and the new Prime Minister V.P. Singh quickly rescinded the presidential notification of October 7. E.C. Dhanwa challenged this removal by the to the Supreme Court, but his petition was dismissed. Now, V.P. Singh government then enacted the that Act of 1991. EC and CEC should be on the same pedestal. It gave the CEC a status equal to that of the Supreme Court judge, and his retirement age was fixed at 65 years. The ECs were given the status of High Court judge, and their retirement age was fixed at 62 years. Okay, and December 12, 1990, T.N. Sheshan was appointed as the CEC. Now, the Congress government, which was headed by P.V. Narasimha Rao, they decided to again expand the body. Okay, and the government brought an ordinance to amend the EC Act, and the CEC and ECs were given equal status by giving all the three the status of Supreme Court judge and the retirement age at 65 years. Now, all three commissioners had equal decision-making power. This was by the Act. The amendment also introduced sections that envisaged that the CECs and the ECs would act unanimously. There could be no dissent, and in case there was a difference on an issue, the majority view would prevail and not the view of the Chief Election Commissioner. Now, T.N. Sheshan was also not happy. He moved to the Supreme Court saying that they want to curb his power. The government wants to curb its powers. And the 5-judge bench headed by the CGI, A.M. Ahmadi, he dismissed this petition. T.N. Sheshan, Chief Election Commissioners versus Union of India, this was the case. And the ECI since then has functioned as a 3-member body. So, I hope you got all the information that I gave you. That's it. Thank you so much for watching.